Hello and welcome to the big picture. The Guwahati High Court has set the cat among pigeons, so to say, with its radical judgment earlier this week, declaring Central Bureau of Investigation as an unconstitutional body and quashed the resolution forming it in 1963. The judgment, which virtually brings the functioning of the country's main investigating body to a halt, also puts into question all the cases being pursued by the CBI. The double bench order of the High Court has held that the CBI is neither an organ nor a part of the Delhi Special Police Establishment Act, and that the CBI cannot be treated as a police force constituted under the Act. The controversial judgment will of course be challenged in the Supreme Court, as the government has indicated already. However, today we will discuss the implications of the judgment and why CBI has not been given legislative backing so far. To discuss this, I have with me Arun Bhagat, former Additional Director of the CBI, TSR Subramanian, former Cabinet Secretary, Sanjay, Parikh, a Supreme Court advocate, and Saikat, Datta, Editor of National Security at the Hindustan Times. Welcome to all of you. Mr. Arun Bhagat, I would like to come to you first. Do you think that this order of the Guwahati High Court, has raised certain important questions about the CBI?
Well, more than about the CBI, I think it has raised very many questions about how our government works, because it's a very curious situation which seems to be out of Alice in Wonderland.
Right.
I mean, 50 years this organization has been there, and this organization has been entrusted with specific tasks, investigations, inquiries, reports have been submitted to the highest courts of the land. Even now, at the present moment, they are investigating a number of cases which are being overseen or monitored by the Supreme Court of India.
Right.
And you must remember that it is what you can get from the excerpts which have come out of the judgment in the newspapers is that they have found that in the notification which was made, there is little or no reference to the Special Police Establishment Act.
Right.
Now, you see, the nomenclature which was changed, that was all that was done, was it was changed in 1963. Otherwise, this is the act was, or rather the order was passed sometimes in 1941.
Right,
and
43.
Then,
it was a 43 Act.
All right, 43, and then it was subsequently amended in 1946.
1946, yeah.
So, you see, I mean, just see, it's half a century old and nearly 3/4 centuries old on the other hand.
Right.
So, yes, it does throw up many questions, and I hope the government will be able to get a stay order from the Supreme Court very quickly.
Isn't it quite curious that you were also there, you were additional director there? If we go by this judgment, all that you have done during your tenure there was unconstitutional, virtually.
Yes, and of course, I'm probably no civil liability will fall on me, but criminal liability does.
Yes, Mr. Subramanian, I mean, is it an indication of how government works, or do you think that this is another case of judicial overreach?
Well, I don't think it's judicial overreach. It may be probably. I don't know the technical side of it. Probably the lawyer, the Supreme Court constitutional lawyer, would be able to discuss that. I don't know the details, but I think firstly. It appears extraordinary, as Arun Bhagat said, that it has come 60, 70 years after its functioning, and that so many cases gone, etc., etc. Now, for the future, I suppose under General Clauses Act, all acts concluded would not be found irregular. As far as all current matters are concerned, I hope that a stay will come very soon and the matter will get sorted out in the court rapidly. In any case, it should be open to the government to issue a retrospective an ordinance, etc., within 2-3 days, and to regularize it, to ensure that all the existing, only thing is a large number of people may be feeling having a feeling of relief all over India that, in India, the main way to address a legal matter is to filibuster. So they may get another 5 years breathing time due to this act. So that's the way it functions. But it appears really extraordinary. I have not read the arguments or the logic or the validity of that. I think all that will emerge in the next 2, 3, 4 days.
No, but it really sounds funny
But
now, and
we are desperate.
It sounds funny and we are laughing, but the fact of the matter is that it has raised very serious questions actually. Mr. Sanjay Parikh,
Yeah.
Sanjay Parikh, how do you look at this?
Yes,
Sir.
sir.
How do you look at this? Mr. Arun Bhagat and both Subramanian and Arun Bhagat saying, and 60 years this act has been in this has been functioning. 63, the resolution, declaring that CBI has been constituted has done.
Sir,
All these years, has there been any such any challenge to this resolution, or is this the first time which the courts have taken up this matter?
Yeah, actually, I got this judgment and I was able to go through 89 pages. I have gone through them.
Okay.
And a very curious thing is that this question was put to the Additional Solicitor General and amicus curiae both.
Right.
Whether the Supreme Court ever examined this question, how the CBI was constituted. And they said, no, this question has not been examined. What has been said by the Supreme Court in several judgments is, under the Delhi Special Police Establishment Act, CBI has been constituted.
Yes.
Now, the ASG was reading only those 2-3 lines from all the judgments, but was not able to point out that the Supreme Court considered this aspect.
What
Now,
are you?
the
Are you?
court
Are
has
you?
gone
Sorry,
in
sorry,
great
Mr.
detail.
Sorry, Mr. Parikh. Are you talking about what happened
Yeah,
in the
yes,
Supreme
sir.
Court today, or are you talking of the Guwahati High Court proceedings?
No. I'm talking about the judgment because I went through the judgment
Okay.
very carefully.
Okay.
What I'm trying to tell you, a question was posed in the judgment
Okay.
to the lawyers who are appearing because central government was represented by the Additional Solicitor General.
Okay. Central government
And
was
amicus
represented.
curiae was also appointed.
Okay.
So they were pointedly asked whether this question was ever raised in the Supreme Court about CBI's constitution. They were not able to reply.
Okay.
First time actually the Guwahati High Court has examined this question in great detail by looking into all the constitutional entries.
Right.
And they have said that it is only created by an executive instruction.
They've also
You say
gone
it's
into-
actually a departmental kind of instruction, not even executive instruction.
They've also
Yeah.
gone into the Constitutional Constituent Assembly
it's
debate.
Actually, debates have been gone into because the Additional Solicitor General pointed out different entries. He said it is entry 8 of list 1, then entry 80 of list 1, etc. And all these aspects are considered by the Guwahati High Court.
Right.
So it's a judgment which requires consideration. I think it's a serious question.
So you think that now that the order is in force as far till the Supreme Court gives a stay on this order is in force. So does it mean that the CBI's functioning
Yes,
comes?
yes, of course.
Does it mean that the CBI has to stop functioning or continuing investigations?
No, naturally, because when the judgment came, I was also a little taken aback because it raises a very, very serious question. Because once a judgment of this nature has been given, saying that they have no power in law to do the investigation, then unless a stay is granted by the Supreme Court, the CBI cannot function.
Okay. Saikat,
Yeah.
Saikat, I suppose you have been in touch with some of the CBI, the CBI people. What do they think, and what is your view on this? I'm sure but during the Lokpal debate, this whole the functioning of the CBI, how it should be, the question about having a legislative backing for the CBI, all these were discussed during the Lokpal debate in this country. So how do you look at this whole thing? Saikat?
Sorry, I missed the question. The connection was cut off.
Okay, Saikat, my question is that how do you look at this whole thing? You must have been in touch. You must have been in touch with the CBI people, or the constitutional lawyers and things like that, or in the government. How is the government reacting to it? We have just seen some brief reports saying that the government will, of course, go to the Supreme Court.
2 quick points. The first point, if you read the judgment very carefully, it's a very, very fine judgment, and I think both the justices in the High Court have spent a lot of time thinking
Right.
about this and examining each and every document that was brought to their notice.
Right.
And I think the additional Solicitor General did not take it as seriously as he should
Exactly.
have, and probably did not also give the right kind of affidavits. Now, the judgment interestingly raises several points, especially the whole debate about Article 73 of the Constitution, which
Right.
empowers the government to pass such a ordinance, which will then be used to create any agency.
Right.
Some factual parts. In 1943, there was an ordinance which the British government had created, which
Right.
had lapsed in 1946 because the emergency powers under which the agency had been created was taken away.
Right.
Instead, in 1946, a new act, the Delhi Police Special Establishment Act, was passed,
Right.
and that created an organization which will only look at corruption issues.
Right.
In 1963, when the government then started looking at tackling corruption, they did a very lazy job, and instead of constituting and passing a statute, they just went ahead and passed a ordinance which, as the
Not
judgment has...
it is not an ordinance, it was a resolution actually.
No,
It
it
was
is
just
an
a
ordinance,
resolution.
but it has not even been signed by the
Signed by the
President
President.
of India,
Right.
which has been brought out by the judgment. So
Right.
this is the way they have gone about it, and what they did was they made the Delhi Police Special Establishment Act a part of the agencies, one of the charters that the so-called Central Bureau of Investigation will do. Now this raises a very interesting point. If
No,
this
no,
is the
that's
way
right.
you raise and create these agencies, it raises a very, very valid question about the constitutional validity of agencies, not only the CBI but also the Intelligence Bureau, the Research and Analysis Wing, and the NTRO,
Right.
which have all been created by these government ordinances.
Right.
And this is all the more interesting because the Constitution in Schedule 7 clearly states that a Central Intelligence Bureau and a Central Bureau of Investigation should be created by an Act of Parliament.
Right.
And because we don't have an Act of Parliament, these law enforcement agencies can do whatever they like without any kind of public oversight.
Absolutely. Mr. Bhagat, there has been a debate on in this country for some time now. In fact, the Vice President of India himself has been talking about this, about not just the CBI but also the intelligence agencies, how they need legislative backing and things like that. But at your level, at the level of you senior people who have been inside, who have held very important positions in the establishment, whether it's CBI or IB or things like that, these issues had never come up for discussion, is it so far?
No, I think a lot of internal discussion has gone through, but let me correct the speaker who was there a while earlier. Neither the NTRO nor the RNAW nor the Intelligence Bureau are law enforcement agencies. They do not have any police, any powers whatsoever. Neither of arrest nor of search, nothing like that. They are just executive departments of the government of India. That's it.
Sorry, Mr. Bhagat. Does that mean that there is no need for a legislative backing for these bodies?
No, I never said that.
Okay,
Saikat,
one second, sir. Saikat wants to react. Yes, Saikat.
I just want to clarify to Mr. Bhagat that they have indeed been notified as law enforcement agencies by the Ministry of Home Affairs, and they have specifically mentioned these agencies, barring NTRO, both the IB and the RAW are part of the 9 law enforcement agencies as well as the CBI who are permitted to conduct surveillance. Now, in law, when you recognize a body as a law enforcement agency for whatever you want to do, it therefore in law becomes a law enforcement authority. And therefore, the Ministry of Home Affairs through notification has already notified them as law enforcement agencies. So there is no doubt in law that they are law enforcement authorities.
Yes, Mr. Bhagat.
No, but this is only a partial power. You see, you
No.
can't call them a law enforcement agency unless they have all the authority of law.
Okay.
And that has got many ramifications. So this may be for purposes of surveillance. They have notified this, but that doesn't, I don't think, makes them a full-fledged law enforcement agency.
No, but what is the point, Mr. Bhagat? What is the point you're trying to make? Are you trying to say?
I'm just trying to clarify this issue about the NTRO, the RAW, and the Intelligence Bureau. That is what I said.
Okay, coming back to the CBI. Yes, Sanjay, you wanted to react?
No, what I wanted to say, clarify the legal position. See, it is like this. The state police has power of investigation, arrest, etc., filing charge sheet.
Right.
Now, what the High Court has said as far as the CBI is concerned, the powers which have been given are powers to conduct the inquiry.
Right.
Now, by executive instruction, you can do the inquiry, which will be a administrative kind of inquiry.
Right.
It will not be a legal kind of an inquiry which is required to be done. What has been emphasized actually, which is the crux of the entire judgment, is that it has been created by executive instruction, whereas the enforcement, because if you are curtailing anybody's fundamental rights,
Right.
you can do only by law.
Right.
For example, suppose you want to arrest somebody. Now you can arrest somebody only by under the provisions of CRPC.
Right.
And what has been said is that these powers have not been given to the CBI. That's actually the entire crux of it.
Absolutely, and also, if I am right, the order also talks about CBI having jurisdiction only over union territories and not over the states.
See, the question is, let me tell you,
Yes.
if we are able to, and the central government is able to establish that CBI has been constituted under the Delhi Police Establishment Act, then the CBI may continue probably the functioning. If they are not able to prove that, then there is nothing else, there is no other argument which has been raised. Then it becomes only executive body, and executive body certainly in law cannot do the investigation.
And
it has to be done by a law made by the parliament.
It will have no powers of arrest, or it will have no powers of investigation.
There is no investigation, no nothing, not at all.
Okay,
Yes,
Mr. Subramanian, you know this.
Yeah.
In your experience as a cabinet secretary, and even otherwise, these issues were never came up before the government, and you know, because whenever CBI is talked about, whenever there is a problem in any state and CBI inquiry is demanded for or ordered, it is the state governments which has to give permission. Unless the state governments give permission to CBI, will not be able to register an FIR. You think that had put the entire thing in, people had become complacent and did not look at this whole thing as it should have been?
Yeah. That's right. I think, Girish, you summed it correctly, because we have been complacent. Somebody has mentioned we have been lazy. I am not still even now convinced that the judgment of the court, probably all the documentation required, I'm sure furious research is going on. If there is an official formal linkage with Delhi police establishment,
Yes.
in that act, then the powers would be there. It is possible that the additional solicitor, the AG, whoever argued the case, did not give all the documents. I would find it astonishing that 70 years later it has no legal backing. I would find it really astonishing.
Yeah, absolutely.
But it is entirely possible. Somebody has been careless, somebody has been lazy. I don't think we should bring in raw IB, etc. here. They are not really arrest or investigation agencies. They are sort of intelligence agencies. You don't have MI5 or you don't have ISI coming under Act of Government of Pakistan. We can't get
Again,
we don't
factually
expect that to
incorrect.
happen.
That is a factually incorrect statement.
While what has happened is correct.
One second, sir. Mr. Subramanian, let Saikat, yes, Saikat, quickly.
Just quickly, what Mr. Subramanian said is factually incorrect. MI5 by the British government has been put under the Security Service Act of 89, and MI6, which is their external agency, has been put under the Intelligence Services Act of 1994. All I am trying to say is that this juncture is an interesting debate to revisit how agencies are created and how they are in keeping with our democratic norms and traditions as mandated by the Constitution.
Absolutely. That is,
Girish.
Yes, Mr. Subramanian.
Girish.
Yes.
Girish, that's a different point. It was not till 89. MI5 has been in existence for the last 70 years. It is only in 89 probably it has come in.
Right.
ISI in Pakistan is not, but then that's not the issue here.
That's not the issue.
The issue is that we need our CBI and our national intelligence agencies, etc., to be reviewed in the context of Supreme Court, Vinitnarayan, and a number of other cases. We have not done that with care.
Absolutely.
This is an opportunity.
Absolutely.
This is an opportunity for us to review it. Make sure what the control mechanism is, make sure what the mandate is, and make sure the various agencies do not overlap. But I don't think it's a catastrophe. There are clearly weapons available with the system
I'm sure.
to ensure that all the work so far done by CBI does not go waste.
I am sure. Mr. Bhagat, I'll come to you, but before that, Sanjay, you know, this is the Vinitnarayan judgment, which Mr. Subramanian also was talking about. The Vinitnarayan judgment, you know, is interesting because I think it went into this issue also. It says, I'll just quote one or two sentences from that. We are informed, I'm quoting from the Vinitnarayan. We are informed that almost all the state governments have given concurrence for extension of the jurisdiction of the Delhi Special Police Establishment Act in their states, with the exceptions of only a few. The result is that for all practical purposes, the jurisdiction in respect of all such offences is exercised in the consenting states only by the CBI and not by the state police. This is the significance of the role of the CBI in such matters, and therefore technically the additional jurisdiction under the general law of the state police in this matter is of no practical relevance. Mr. Sanjay, you think this, this judgment in Vinitnarayan had brought about this kind of a complacency to look into this whole thing, and now the government finds itself, or all of us, why it's not just a problem of the government, it's a problem of the entire country.
No, Girish.
Sanjay?
No, Girish, actually the problem is this, that you are right, you are quoting from it, but I agree with Mr. Subramanian. Probably there is some argument which is missing, because unless we bring CBI, because all the judgments you look into, they refer to the Delhi Special Police Establishment Act.
Right.
And within bracket they say CBI, which has been constituted under the Act.
Right.
So it is the consent which has been given under Section 5 of the Act by different states. This is what has been referred to. But categorically, the High Court has said that first time it is examining whether CBI has been constituted under any valid law of Parliament. And there was no answer from the SG. He only cited this particular executive instruction backed by certain entries in Schedule 7. So this is the problem. So I hope, and I think I'll also look into it, that there is something which is missing, because it cannot be that CBI, that there is no document, that it is not constituted or part of the Delhi Special Establishment Act. I hope Mr. Subramanian in that sense is right. It has to be looked into.
Sanjay, I just want to quote another sentence from that from the Vinitnarayan. I want you to hear this and say if it makes sense. It is therefore the notification, I am quoting from the Vinitnarayan, it is therefore the notification made by the central government under Section 3, which confers and determines the jurisdiction of the CBI to investigate an offence, and once that jurisdiction is attracted by virtue of the notification under Section 3, I suppose this Section 3 is Delhi Special Police Establishment Act. The actual investigation, I am quoting again, the actual investigation to be governed by the statutory provisions under the general law applicable to such investigation. This appears to us the proper construction of Section 4(1) in the context, and it is in harmony with the scheme of the Act and Section 3 in particular. Saikat, is this what the government had been relying upon to not having had taken the trouble to give a legislative backing to the CBI?
Exactly. You see, for a long time the Delhi Special Police Establishment Act has been believed or has been understood or interpreted as the act which created the CBI. But as the Guwahati High Court now brings out, this apparently is not the case anymore, because they probably did not close the loop when you're creating another act. You should have gone back to Parliament, ideally, and then passed another act which would have been in the CBI Act. So this seems to have been missed in the checkered history of the Central Bureau of Investigation. As a result, we are in this situation today.
Mr. Bhagat?
Yes.
Mr. Bhagat, the Vinitnarayan judgment, I'm sure you're familiar with that. You think what the Supreme Court said in Vinitnarayan is what had brought about this complacency, because it says that, I hope you heard me quoting from it.
Yes, I did, but Vinitnarayan judgment was much later. So, the time sequence doesn't match up. Now, if the decision was taken in 1963 to rename the Special Police Establishment, and it was designated as the CBI, and after being given the name, it got its powers from the Special Police Establishment Act of 1946.
Right.
So that, I think, is the position which perhaps was not conveyed in a proper manner, And of course, there would be certain technical faults as has been. You see, all the powers which the police officers have emanate from the CRPC, the Code of Criminal Procedure.
Code, yes.
So they get their powers from that.
Right.
And once they are notified, they have to be declared to be a police officer in terms of either by the state acts or by a central act.
In fact,
which is what is the constitutional provision.
But which is what is being questioned by in this order of the Guwahati High Court. They say that under the CRPC they don't have the powers, the police powers. In fact.
Well,
anyway, I'm sure, Mr. Subramanian, last words to you. You think that you just now said it is not a catastrophe.
It is possible,
but is it?
Girish,
Yes.
It is not a catastrophe. It's not a catastrophe. Girish, possibly there is a gap. Possibly there is a gap. Possibly there is not adequate information. In fact, the state government, for example, can create any agency at any time and confer it with police powers.
Right.
I am not sure that every organization needs legislative backing, either from the state or from the center. But clearly there is an information gap here, number one.
No, 60
but assume
years.
the worst. I am not quite so sure that there's no assume the worst. I think it is not a catastrophe. We only regret a mistake which has been made, which I'm not sure has been made, and close the gap now. And I'm sure we can be retrospective about what we do through an ordinance, through a stay in the beginning, ordinance and a law, etc., etc. All these are possible. For me, it's amusing. Beyond that, I don't think it's a catastrophe.
Mr. Sanjay, very quickly, last words to you.
Girish,
Yes.
one word.
Yes.
Very quickly, because let me see what has been said by Mr. Subramanian. Retrospectivity doesn't apply in criminal cases. Either it will be a nullity if the High Court judgment is correct. Then it can be only prospective, or there is something lacking in the judgment which will be corrected by the Supreme Court. But there can't be an ordinance which can cure it. No retrospectivity can cure it.
Okay.
That's actually the law.
Okay. I think we have come.
CRPC, not civil.
Okay. And on that note, we need to end. But the fact of the matter is that it has opened up avenues for a new debate, and possibly how this is going to be remedied. We'll wait and watch, but certainly the government seems to have a task on hand to get out of this problem which the Guwahati High Court has put it in. Thanks to all my guests, Mr. T.S.R. Subramanian, Arun Bhagat, Sanjay, Parikh and Saikat Datta. Please keep watching. We'll come back with another issue on the big picture, same time on Monday. Meanwhile, have a great weekend.